Mr. Dickerson, come on up. Counsel your appearance for Mr. Dickerson.
Morning, Your Honor.
Morning, Your Honor. Leslie Knapp, 34696, comparing on behalf of the defendant, Mike Dickerson.
All right, I've got a plea agreement that says Mr. Dickerson's going to plead no contest to both count 1 and count 2, correct?
That's correct, Your Honor. Count 3 will be dismissed. Both pleas to be assault charges taken under 771.1, and we further elevate sentence. 3 months probation, which mental health evaluation, treatment if recommended, and no contact with the complainant.
All right, Mr. Dickerson, do you understand your rights and the options those rights present to you today? Do you understand the possible penalty for assault and battery? Understanding that, are you pleading no contest? Do you understand that no contest, you're literally saying, Judge, I'm not fighting those charges. If I find a factual basis that supports the plea, from that point forward, it's going to be just like there was a guilty plea, there'll be a sentencing. Do you understand that? Guilty and not guilty and no contest meet at the same place. We're heading towards sentencing. Do you understand that? All right, I'm trying to explain something to me and you're talking to her. How's that going to work?
We do have a second complainant that I believe is on Zoom. It just occurred to me. Hussein? Wait, Hussein? No, okay. Yeah,
We do have Mr. Nicely, he's one of the victims here in the courtroom today.
Okay, which is great information, but doesn't help me take the plea.
what is
Do you understand that no contest and guilty both lead to a sentencing?
Let me say this.
No, answer my damn question. Do you understand what I'm saying? Yes or no? Okay, counsel, you can talk to him when I'm done with the next one. We're not doing this while I've got other things to do. He told me he doesn't understand, so obviously it needs some massaging. Did we get the victim on? Nemeth, are you there?
But the victim advocate advised me that he did not answer the phone call, so we're prepared to proceed without.
All right, so Nemeth or Morgan is going to be October 1 at 8:30. We'll get paper notices to that effect. Back on the record with Dickerson.
Sorry.
Jesus, mind you, that we should be guilty.
Okay.
Prosecution should have a jury trial.
Okay. All right, October 29, 8:30 in the morning, bond is continued. Have a lovely day. Mr. Dickerson, have a seat. We'll get you a paper notice.
Yeah. Thank you, Your Honor.
You're welcome.
Mr. Briggins will be on Mr. I would bring to
Thanks, Jim. All right. So number 8. This is it. We ready to drop it outside of just on.
On which file, counsel? Mr. Clark?
Yes,
You're all right, Mr. Clark. We're just waiting till we get all the attorneys in the room.
okay.
Mr. Mohammed. Yeah, we gotta have him in person though. Counsel, what are we gonna do today?
Mr. Lucky's anyways.
Oh, it is? Oh, great.
On page 5, we'll pick up and see.
All right.
And you have both paper and discovery.
We've currently got an exam scheduled next week. Does that work for you? On the 4th at 1 p.m.?
There's that one more copy I can make with what-
All right, so let's just leave the exam as is and talk about bond. Mr. Lecky, this is your file?
Yes.
All right, so currently bond is 100,000, 10%, no contact, no release without GPS tether. We agreed? That's what the ROA says? All right, go ahead.
Yeah.
Hold on, did you put your appearance on? Did I get that? Go ahead.
Hey, good morning, Your Honor.
Good morning, I'm going to your staff, and give the services by Ken Reagan, PA2125. I have this Kevin Parks will appear via Zoom.
You can hear us all right, Mr. Reagan?
I
Or
can't
Mr. Clark,
really
can you hear
hear.
us all?
No, not that good.
Okay, so far all I've got is the attorney's names on the record.
Okay.
And the fact that your exam is gonna be next Tuesday at 1 PM. You got that?
Yes, sir.
I'm having a lot of trouble with my courtroom audio this week, so I'll try to translate. If you can't hear, I'll let you know what we're saying.
Okay, thank you.
I'm sorry, go ahead, Mr. Riggins.
The top charge in this case is a junior felony. It is a police officer position instructing. I haven't done the guidelines. I imagine the guidelines would be very well, possibly probational. He is a half more, I will not that. There is a weapon firearm that's got busted on in 2025. He's already served time on that. Other than that, you know, this is not a case where I can see how a $100,000 bond is. I do know there are allegations of former girlfriend, but I know this charge never came for it because she said that didn't happen. He never had a gun. He never held her cat. You know, based off of what I see, my client was. This was the argument that that came out and next thing you know, there was a bunch of SWAT cars at this house. Client became scared, did not want to come out of the house because there was guns pointed at them. But nevertheless, yeah, my client does not have to play for fear history. My client has family and community ties. He was working prior to this. He was working for a bottle manufacturer. Unfortunately, he does not remember the name of the bottle manufacturer. He intends to get out and go back to work as soon as he gets out. You know, there's a health provision. My client has no reason to be the ex-girlfriend. He's just asking that he can give him a personal bond where he can go stay with his family and appear in court and fight his case.
Mr. Leckie?
Given the original argument and this argument in front of it, Mark, and you said the original bond. And at that time, we laid out the fact that he was a threat to police presence that was there. He stated on so they gave back that I'll shoot any paycheck. I'm sitting here threatening lives of officers to the point where they had him call SWAT. And so 2 hours later, SWAT took the scene. Another hour and a half after that, this is negotiation, the complaining, one of the complaint orders, the penal complaining when this the incident partner came out after that time, and then after a month or time later, the defendant came out. Now, this caused the rounding split of the police department and left their main kind of SWAT full of about 6 hours. 6+ hours in order to effectuate his money now. He did threaten to shoot officers, and there's camera footage that the news picked up of him almost like grappling with SWAT as in being taken out of the building, grabbing his legs around one of their heads, pulling him down. He younger police to community listen to police officers. We also do believe something when this is afraid before. I mean, I've been unable to contact her. This police is unable to contact her. Is a very fearful situation that we're all in. So therefore, Your Honor, because of the Atlantic machine services, the Atlantic machine facts that we have on the record, I think the bond is appropriate.
Yeah, go ahead.
A couple points. He said something about they checked the house. There were no weapons. There were no guns. The girlfriend said there were no weapons. And this isn't where she was with him and looking at him and said, oh, I meant to say the right thing. They had her in a car with the police, talking to the police freely. She said, nope, he never told me I could not leave. Nope, he never had a weapon. So I understand that there may have been some talk back and forth with police. He may have said that. He never had a weapon. He never threatened her. She came out and said, she's not here because I looked at the body cam footage. It is very clear she did not want to move forward with the case. So much so, she thought they were questioning her. She told them, I need to talk to my own attorney. So I think it's a little disingenuous to say that she feels threatened when she was really annoyed. But nevertheless, Your Honor, again, the top charge here is a 2-year felony. I don't think that it's appropriate to have a $100,000 bond based off a 2-year felony. Again, this man was working. he wants to, I mean, he has a story he wants to tell.
Anything else?
So, you know, did read the part of the transcription of the prosecutor as well as that body camera search. It does say that he physically captured a real physically one of her and was pushing her inside of the room. Held up a sign that said help. Was the police officers came in and cover her. She was at one point the negotiator does, you know, after the 3.5 hour mark, she does refuse to come out, saying he's the one that is. But she does say during those 3.5 hours that she was captain forced there, felt afraid to come out, and eventually had to sneak out when the benefits of the bathroom or another. So I don't think it's such a thing at all, but I'll leave it. And again, there's no facts here that are against what the bond was set at, so I think the bond is appropriate here.
Okay, thank you, gentlemen. No doubt, 100,000, 10% is a pretty high bond on this, but we usually don't have SWAT involved on these types of cases either. I'm gonna leave the bond as is. It's only 1 week. Thank you, gentlemen. Are we done or we got somebody else to jail?
And this is for Tuesday?
Mr. Clark, yeah, I'm leaving your bond as is. Your court date, next court date is next Tuesday at 1 PM. When you, talk to the deputy, would you tell them we're ready for Mr. Slade, please?
Okay.
Thank you. Thank you, Mr. Brigham.